Good afternoon, everybody. Thanks for joining us today. I, along with my colleague Erica, are going to be presenting to you today about the 10 hidden legal risks that every growing business faces and how to avoid them, and honestly, the risks that even large businesses face that aren't growing. It's across all boards of the segment. So with that, I will give a brief introduction of myself. My name is Lisa Messner. I'm a partner at McMurray & Schuster. I am also our law firm's practice head over our litigation department. And I am joined today with my colleague, Erica Hollar, who I will allow to introduce herself.
Good afternoon. My name is Erica. I am a senior attorney at McMurray & Schuster. We'll talk about this a little bit as we go on, but I've got great experience. I've worked in-house, both private, and so I think between Lisa and I, we both give a wide array of experience and some good pointers on these risks that businesses are facing today.
All right, and so with that, just a couple of housekeeping matters. This webinar is being recorded, and we want to make you aware of that. It should be available on our website as recorded content within the next week. So if you're interested to watch it again or share it with somebody, it will be available on our website. And then as we go through the presentation today, if anybody has questions, there is a Q&A box down at the bottom of the screen, and feel free to type your questions in. And if we like the questions, we'll answer them. I'm just kidding, no, but please do type those questions in, and we'll try to address each one that we receive. And we did receive one in advance, actually, of the webinar about outsourcing, which I'm going to address later in the presentation. But if there are follow-up questions to that, please feel free to type those into the Q&A box. And then, of course, we're attorneys, so we've got to give our disclaimer that the information we're providing to you today is for informational purposes only and not specific legal advice. Every situation is different based on the facts of each individual circumstance that's presented. And so if something would arise that actually presents a true legal risk, we would encourage you to seek specific legal advice on that.
All right, let's go.
All right. Here's our agenda today. It's aggressive, so we've got a lot of topics we're going to try to cover, at least from a high level, so that we can just make you aware of some of the risks that you should be thinking about for your own businesses. We're going to talk about employment law issues, consumer protection issues, contract issues, IP infringements, regulatory compliance, data privacy, tax issues, environmental regulations, corporate governance, and vicarious liability. So we've got a lot of topics to cover today, and we hope that you find them informative. So first and foremost, we wanted to talk about employment law issues that face companies, because the vast majority of our clients, the vast majority of companies have W-2 employees. The range of those is wide. However, they have common themes in terms of challenges that it presents to companies. So the first thing that I often see from clients' perspectives when they're asking me questions is general employment policies and handbooks. How to implement those, how to have policies that are providing clarity to employees while allowing flexibility for maybe individual circumstances or some kind of exigent circumstances for employees that come up, and the balance of how is an employee handbook treated versus a contract, and how is that state specific, and they vary by state to state. And so we oftentimes counsel our clients on in employment kinds of policies and issues. And just by way of background for me, although my focus of my practice now is primarily TCPA class action defense, commercial litigation, and regulatory enforcement, for many years, for over 7 years, I did employment defense work on both plaintiff side and defense side. So I have a pretty good basis of knowledge for that. And a lot of times our clients find it very, very helpful for some consult on the issues that face them with employees. Another popular question we get is about leave policies, because there's all kinds of different types of leave, and they're governed by different state laws, they're governed by different federal laws, and the types of leave questions we get are not just vacation leave, sick leave, PTO. You're also thinking about things like maternity, paternity leave, how to treat medical leave, whether that's an FMLA, a Fair Medical Leave Act type of leave, or whether it's just an employer who's not covered by that law, figuring out how to navigate an employee who maybe has something very serious that requires them to take a leave of absence. Another question that I commonly get is how to address employee complaints. And so the most common ones that we would see would be discrimination or harassment. There would be maybe potentially other types of complaints, such as maybe issues with pay, or is that equitable across the board. But it is important, no matter how the company views the complaint, whether they view it as, potentially being frivolous, or whether they view it as being very serious, to investigate it, to take it seriously, to internally document what the findings of that investigation are, and then to communicate back to the complaining employee. We've investigated this. We've heard your complaint, your concern, validate those so that the employees do feel comfortable coming to the company with complaints, and then explain what your findings were and what, if any, action will be taken as a result of those findings. Another question we commonly get is how to deal with charges of discrimination, which are filed with government agencies. And those can be filed across a variety of different agencies. Most of the states have a process or an agency to report employment discrimination, and most states run those in tandem with the Federal Equal Opportunity Employment Commission. So it's a dual filing. And so it's important that if there is that type of charge filed with the government agency, that the company undertake efforts to draft a thoughtful position statement to hopefully avoid further government action or further legal action. We also get questions about employee discipline. The key there is documenting it, making sure that discipline is implemented in a consistent way across all employees for all reasons. And then, counseling and coaching in the moment, documenting it in the moment. It is not a good business practice to see an employee with deficient performance and not document that in real time, and rather put that employee on like some kind of double secret probation. That is not going to set out the basis for some kind of discipline, including up to termination of an employee. A big one that I have had personally this year also is wage classifications. And this is because the Department of Labor has, over the last couple of years and going forward, tiered out different salary requirements for exempt employees, carved out different types of high salary exempt employees, and have just generally kind of put that on a 2-year tier springboard that has raised a lot of questions about how to structure employee salaries, how to deal with their commission incentives, because in some instances, those commissions can be rolled into what an effective hourly rate is for a non-exempt employee. And it creates a lot of internal confusion when salaries need adjusted and payroll needs adjusted. And so those are things that we oftentimes see as well. And then the last point that I want to make about employment law issues are credit checks and employee backgrounds. So oftentimes, I don't think that employers are thinking about the fact that when they run a credit check on an employee, there is a law called Fair Credit Reporting Act that is triggered, and there's a very specific notice that you must give to the employee. Particularly true if the employee is disqualified for employment due to their credit history, because that is an adverse action under the Fair Credit Reporting Act, and it requires a certain type of notice. And I've seen a lot of class actions over the year based on just that simple notice not being provided, and it's a very easy fix. All right. Consumer protection issues. This is a hot topic for really any companies that are interfacing with the public. So the things that we see, or at least that I see, and I'm going to ask Erica to weigh in too, because she has a big focus on this as part of her practice, is we oftentimes see the need to respond to consumer complaints that can come in a variety of different manners, whether that's an internal complaint to the company, or whether it's an attorney general type of complaint, Better Business Bureau complaints, but there also can be complaints to federal agencies like the FTC, the CFPB, and we see those oftentimes as well. Another issue that many of our clients face on the consumer protection side is proper consumer disclosures. That goes across a variety of different segments of business. There's very specific disclosures for insurance products, financial services products, automobile industry, any like door-to-door sales type of business where there is a requirement that the consumer be given a right to rescind. And so just keeping on top of what your required disclosures are, which can vary across industry and can vary across state. We also get questions about how to handle third-party verifications for certain services. Most commonly, I see that in energy and independent retail energy and solar, but third-party verifications for your specific type of service might be required. Handling consumer refund requests and dealing with chargebacks on credit cards, that is something to be mindful about, because if your chargeback rate with your credit card provider is too high, it could disqualify you for merchant services. It could raise a flag with a regulator. And so it's something to be mindful of. And it's particularly coming up, at least in my experience, with subscription-based services. Mm-hmm. So if your company offers those kinds of products or services to consumers, be mindful to watch your chargeback rate on the credit cards. And then, and I had mentioned this just previously under the employment context, but making sure that proper disclosures and notices are being sent if you're doing any kind of consumer credit check. Again, if someone is disqualified for a product based on their credit score, there are certain forms and adverse action notices that need to be provided. In addition, depending on what type of potential lending product is being offered, you have an obligation to provide them with a risk-based pricing disclosure, which is a required disclosure under the CFPA. So those are just things to keep in mind. And then Erica, did you have anything to add? Because I know that this is a big part of what you do as well.
Yeah, I would just add, so we always say here that Helen McMurray, one of the partners, she says consumer complaints are a gift. And, when Lisa was talking about responding to the complaints, I think it's important with the way that businesses are advertising, and there's a lot of omni-channel opportunities. Complaints aren't anymore just a traditional, AG complaint that you get or a BBB complaint. Often regulators are considering like social media posts as complaints when they're doing an investigation, or even, some of that chargeback information. So anything that you're getting, my biggest piece of advice would be to just make sure that it's addressed, or at least attempted to be addressed, because that's really really what is it? Happy wife, happy life, almost like happy consumer, no investigation. So, that's all I would add.
Yeah, and I think that that's a good point, because if you look at a consumer complaint as a gift, it may also help you identify either a regulatory issue or a rogue employee issue, or something that you can address internally before it becomes a government enforcement action.
Perfect. Okay, I'm gonna take it and talk about contractual disputes, which is probably the driest of all of these topics. I don't know, tax might be a little drier, but I was researching and, getting myself ready, and I was like, there's some quote about a contract worth a piece of paper or something. So I looked it up. A verbal contract is worth about as much as the paper it is written on. So, my number one piece of advice in terms of contractual disputes is make sure you have a contract. A lot of times businesses, they'll go off of like a good handshake, or, business dealings are so quick that it's like the work is done or the service is provided before you've even had a chance to look at the service agreement. So that would be my number one piece of advice, is to, one, make sure there's a contract. Two, make sure that you read it. In terms of reading it, this one can seem obvious, but sometimes it's tricky when you are doing business dealings. A lot of times some of the master terms of a contract, so for instance, you might have a purchase order that will say, we want to buy 15 widgets at $10 a piece. That'll be on there, that we know. But then at the bottom or somewhere, there's a language that incorporates different terms. And oftentimes people don't, one, even realize that that's there, and certainly don't read it. So, just make sure that you're aware of all of those kind of like tricky obligations that you might be binding yourself or your company to. When I was in-house, there were always 4 sections of a contract that I would look at and pay special attention to, regardless of what the service was, how much the dollar amount of the contract was. And that was indemnification, insurance provisions, the parties to the contract, and limitation of liability. So indemnification is important because if something were to go awry, this is protecting yourself or your company. It doesn't often prevent the headache that is involved with a legal dispute, but sometimes monetarily it can help. Insurance provisions, it's great if you are working with vendors or partners who have insurance that would cover anything that might go awry in a business dealing. But I would caution, same with indemnification. If you've got this great indemnification to be able to collect from another vendor, but they're defunct or they have no money, it's worthless. So same with insurance provisions. If, to have them there and make sure that the coverage, both for the type and the amount, is appropriate to what the service is in the contract. Parties to a contract, I think this one is important, especially when we're dealing with smaller companies. Make sure that you're cognizant of, is only the company named as a party to the contract, or is perhaps the owner of the company, or the head of marketing, whoever it might be. Just, I always like to pay attention to who is actually bound by this contract and what are their obligations. Limitation of liability, same thing. If it's in there and it's written right, it's great. But there's different things that can be included in that, whether it's the type of damages, the amount of damages. So those are the 4 that I would make sure, if nothing else, when you are looking at agreements, you look at those. And sometimes it's hard, just in practicality, if I'm a little startup company and I'm doing business with Google, for instance, you have to consider the bargaining power that the parties have. Obviously, Google is probably not going to, they've got standard terms that they agree to, kind of like take it or leave it. But if you're a small startup working with another small startup, there's probably a better chance that you can negotiate those terms. So, all of these things are important, but I would just say, keep in mind too, there's always more to the story. So that's my spiel on contracts. Hopefully you all found that helpful. Now I'm going to talk about some intellectual property. In my opinion, intellectual property for a company is arguably the most valuable asset that they have. Take Coke, for instance. Everybody knows Coca-Cola. Their recipe is something everyone knows, but nobody really knows. So it's kind of what makes the company the company. When I was working in-house before coming back to the law firm, I worked with the marketing department at the company that I was at, and we got questions about IP stuff all the time. And I like to think of IP as you can either be proactive or defensive. So if you're proactive, you want to make sure that you're protecting your own marks. If you've got some sort of trademark that is special and you think that it's really good, do you want to register that? When one of the questions I got too, and this is it's kind of nuanced, but when you are developing marketing materials, they would say, do you use something as simple as should I put the TM or the R? Yeah. And there's different rules based on, whether the mark is registered, when it was registered, where it's registered, or if, it's just a mark that you hold out as your own. So there's all different little types of things to consider when you're dealing with intellectual property. Another thing that, we would talk about at my previous role is it worth registering a mark? So we've got this new product that has a special mark that we think it identifies this product. We only want our company using it. Should we register it? Well, of course, if you register it and you get an approved registration with the US Patent Office, USPTO, Patent Trademark Office, that's great. But what happens if you go to register it and through that process, other parties are able to challenge your registration? So let's say, through that process, I want to use a certain name for a new product, but there's actually another company that has a name not exactly the same that's very similar. They're able to challenge that registration. And then once they do that and you're notified by the USPTO that there's been a challenge and it gets denied, you're not able to use it. It's done. So sometimes, depending on the scope of what you're doing, it's better to just use a mark. Obviously, you don't want to infringe on anyone else's marks, but don't represent it as a registered mark. The other thing, like I said, is we can defend IP issues. And oftentimes this comes with a cease and desist letter. We'll get them from clients, whether it be their website has something, or maybe there's a commercial where they are using somebody else's copywritten materials. So it's always better to be on the proactive side of IP issues rather than the defense side, but it's something that you do need to be aware of. And then at the end there, I just have trade secrets and NDAs. NDAs kind of non-disclosure agreements tied back to the contracts, but just be aware if you have certain employees that, for instance, someone that's working, we talked about Coke earlier, someone that's working at Coke and they have the recipe, you might want them to sign an NDA to be able to protect those marks and some of the trade secrets. All right, moving along. Okay, regulatory compliance. This is kind of like the bread and butter of where our firm started. It's fascinating. I feel like I still learn stuff every day. The existence of laws that I didn't even know existed. It's just, there's so many facets of it. And I put at the bottom, you don't know what you don't know. And oftentimes we see clients who, with no ill intent, they are not complying with regulatory laws. And the tough thing about regulatory laws is, unlike a criminal charge where you have to have intent, that's not the case with a lot of these regulatory laws. Regardless of whether you knew of the law, regardless of whether you had intended to violate the law, that doesn't matter. If it happened, it happened. And a lot of the clients that we work with, for instance, Lisa said she does a lot of TCPA work. Let's take those TCPA class actions, for instance. It's a slam dunk that a call was made. There's records, you can't really deny that. So it's really important that if you are in one of those highly regulated industries, that you do seek counsel from someone who is knowledgeable, and can help you identify the risks. And I think another thing that's important is regulatory compliance isn't always black and white. There's oftentimes a lot of gray. So I would suggest that you not only find a counsel or someone who can assist you, who's knowledgeable about the laws, but also who you trust and who you feel comfortable is going to help you assess your risk and be able to make a business determination as to where in that gray area your business fits. You might be a more conservative business where you want to play more by the rules, or you might be a little less conservative and you want to push the envelope as much as you can. And, as long as you're in that gray, arguments can be made either way. So I just put here, some of the things different industries, for instance, telemarketing, door-to-door sales. I do a lot of work with charities. There's all sorts of registration requirements for these sorts of industries and many, many more. Charities is a good one. I think we all think charities are these wonderful organizations that are trying to do good. And, for the most part, they are. But they didn't, I work with so many charities that don't even know that there are registration requirements for both, whether it's with the Secretary of State or their state or a tax entity. So again, I would just encourage you to, evaluate your industry, consult with someone who can identify those requirements and someone that you trust to be able to assess risk and be able to come up with a plan that's specific for your business.
And we see this too, Erica, for financial services, insurance companies, credit repair, across all of these industries are highly regulated. And the other piece of it is that the law is ever changing.
Sure.
And the regulatory enforcement appetite of the government is always changing depending on circumstances. It'll be interesting to see how things kind of go forward with kind of the changes that are coming in the next year in the regulatory landscape, but it always changes.
Yeah.
And so that is another reason that's really important to seek counsel, because we're staying on top of these types of things so that we can best advise clients as to how they might need to modify their business one way or another.
The other thing that's often really frustrating for clients is if you have a business that does business across different states, oftentimes these regulatory rules vary by state to state.
Yep.
So one of the things that we do is, how do we come up with a plan for a business that not only complies with their home state, but all other states as well. So it's tricky, but
there's a path.
Yeah,
it can be done.
All right.
Data privacy and security. This is a hot topic. It's a hot topic, I think, for most industries. And it's even interesting because as we were preparing for this webinar, when I checked the mail yesterday, I got a notice that I was subject to a data breach for a service that I was provided with. And it's across all areas. I mean, we know that even just recently, Marriott had to settle a data breach issue with the FTC, and it was over $50 million in penalties. And now Marriott is large, and I'm sure that the data breach was large, but a lot of our clients are handling data that has personal information to people, whether it's for insurance, whether it's health information, or whether it's credit card information, banking information. social security numbers, addresses, dates of birth, all of the stuff that can culminate in somebody's identity being stolen. So we work a lot with clients to talk about data privacy and security and what are the best practices to protect this information. What are your privacy policies, your internet terms of use? And then a big one that's kind of coming to the forefront is proper collection of consent for electronic signatures. So if you think about when you use DocuSign, you have to consent essentially to provide your electronic signature before it's provided. And so that's one that we also see fall through the cracks. And I know just from our own law firm's management of the data that we have, it is a task that is large and involved, but it can be done, and it can be done for small businesses. Our law firm was certified through a process to make sure that our own data was protected. And so from that standpoint, we've been through it ourselves.
Yeah.
And we're very well in tune with what needs to happen to make sure that businesses are protecting that information. All right, taxation errors. Of course, Erica asked me to talk about the most fun topic. We do know that the only thing certain, right, is death and taxes. So understanding that that there is going to be nuances to your specific business with tax issues. So certain types of businesses are going to have different issues with respect to sales tax that might vary from state to state. So for example, in Ohio, licensed beverage, people with liquor permits have sales tax requirements that are handled in the state of Ohio, at least by the attorney AG. So if they fall in arrears, they're going to get pursued by the attorney general. And a lot of the tax laws will go back on individual officer owner of the company liability if taxes aren't paid. And that's both at the state and federal level. So it's very important to make sure that you're documenting deductions, that you're having an accountant review things properly, and that you're getting, if you have quarterly payments due on a certain type of issue, whether it's sales tax or federal tax, that you're looking at those things. Also need to take a look at employee withholding taxes because there's certain obligations on employers to do those. Typically, your payroll processors will help with those things, but you just want to make sure that you're asking the right question of the payroll processors to make sure that they're handling the employee tax correctly, making sure they're doing things like withholding the proper local tax for the employee, and maybe the local tax. Maybe the employee has local tax for where they live and local tax for where they work. And there's just a lot of moving parts with those kinds of things. And we have a good network of business accountants for that side of it that are helpful. And I have done many negotiations with the Attorney General's office, at least here in Ohio, to reduce exposure for sales tax issues, because one of the problems that we see is that if somebody falls behind on their tax arrears, the penalties very quickly far exceed what your tax is. And I remember one instance, and it's been a few years ago, where somebody had a sales tax calculation error, and it was something in the nature of $2,000. By the time they were done with penalties, it ended up being over $50,000. So it very quickly can snowball to a point of, for a small business, very, very crushing. So just important to stay on top of those things, document them, and make sure you have a good accounting team around you.
I think you raised a good point in talking about the taxation errors and how we have professionals that we work with. You know, when you're trying to find someone to help your business with just general legal concerns, it's not necessarily important that they know the answer to every single question that might come up. In fact, if they represent that they do know the answer to every single question, I think that would kind of be a red flag. But rather, you know, they need to know how to help you identify areas of risk. And if there's something, for instance, I am not by any means an expert with tax or anything like that. I would not personally probably try to handle a tax issue, but there are plenty of people in our office who, if we can't, someone else in the office can't, we know people who can. So just, you know, that's something I think to keep in mind too, that no one's going to really know it all. So
I think that's a good point.
okay, environmental regulations. This is something that's kind of depending on the industry and your business, you know, this could have more of an impact on you than others. You know, one of the things that we're seeing is, Lisa talked about the data privacy certification that our office has gotten. Depending on what industry you're in, there are different certifications for environmental aspects. So sometimes, you know, if you're a publicly traded company, that might be something that's very important to shareholders. So just to be aware that that's out there. Marketing tactics, a lot of times these environmental regulations can impact how you're marketing. We'll see things like non-toxic, eco-friendly, recyclable. The FTC has actually published what's called the Green Guides, and these, they lay out recommendations, I guess, for when you can use certain terms and when you can't. So if you are in an industry where, you know, you want to say that something is eco-friendly, or bamboo is another one, that's a good resource to look at to make sure that you are complying with those laws. And then obviously too, production activity and manufacturing, you know, the goal is to of all of these laws is to reduce emissions through energy efficient processes. So again, depending on your industry, that could have more of an impact on you than others. Okay. Corporate governance. This is kind of like a catch-all from everything we've talked about, and Lisa's going to talk about vicarious liability too. But this is basically what is going to help your business make the right decisions while protecting the stakeholders in the business. So whether that's your management, your owners, shareholders, suppliers, your customers, the goal is to have these policies and controls in place so that you know what sort of behavior to engage in and to refrain in. You know, something you might have your strategy laid out in a document, or you might have your values or your mission statement. All of that is part of your corporate governance. And the goal of the corporate governance is to keep you in line with the law. It sets the framework for success. And I was reading through, and I saw something that said that a good corporate governance program can even help with private company valuation. And I kind of thought, really, but I mean, it's true. So if you have all of these plans in place and you are following them, investors probably have more confidence in your business and your dealings. So that's corporate governance. One thing I do mention is, you know, we talked about policies and procedures. And I was going to ask you when we were talking about the employment stuff, oftentimes we'll see companies that will, you know, Google employee handbook, and they'll just download it, save as John's, or, you know, X company's employee handbook, never read it. It goes into a drawer, never to be seen again. That's not helpful.
No.
In fact, I think sometimes that is more damning than just not having anything. I mean, neither one is a good option, but if you have all of these policies and procedures, it's important that you train to them, you practice them, you evaluate them on a regular basis, whether that be every 6 months, every year, and then you adjust them as necessary. And then, you're auditing against those. So it's not enough, unfortunately, to just put something on a piece of paper and say, oh, we drafted our paternity policy. That's probably not a good example, but our social media policy, and nothing is done of it. So
Yeah, I think that that's a good point. And then in addition to the corporate governance issue, it ties a little bit into regulatory issues because most corporations have some kind of master plan, and whether that's going to be your articles of organization, your code of bylaws, whatever those things are, dictates how the proper running of the corporation should go. And if you're in a regulated industry and you're not following those things, for example, not taking votes of board members on a quorum or not following the proper procedures that are laid out in those things, it can unwind and undo things that, such as maybe government filings that then weren't valid. And it can get the eye of a regulator. So corporate governance touches on a lot of different things, including the regulation piece, employment piece,
sure.
Even employment of the board.
Yeah.
So corporate governance is very, very important. It is, from the 20,000 foot view in my mind, probably the starting point for any business.
100%. Right.
All right, vicarious liability. So, who you choose as your business partner does matter. So what vicarious liability means is essentially, could your company be liable for something that a vendor or a third party did, or even that an employee did? And so there are certain circumstances where that comes up. For me in particular, where I see it most often would be, just because of how much I work in the telemarketing space, third-party vendors who engage in telemarketing. And I know that we had a question in particular prior to the webinar about outsourcing, particularly with companies that might be in remote areas or might be outside of the United States. And that is oftentimes where we see it come up, because sometimes those companies are overstated but underproduce, promise things such as proper consents that they don't retain or don't have. They might be under an indemnity obligation, but if they're overseas and they're not collectible and they're not able to be served with a lawsuit or located, it can present a lot of challenges. And at the end of the day, I've seen many instances where there is a run at claiming that a business who partners with some kind of overseas source could be held vicarious liability standard. And what that standard is under kind of 3 different prongs. So a little law school lesson. You can be vicariously liable under a standard of actual authority, apparent authority, or ratification. So actual authority would be you saying you actually have the authority to violate the law. No one's really going to do that. Apparent authority would be you have the authority to use my name. And ratification is I knew or should have known you were violating the law and didn't do anything about it. It's that third area where, particularly for the overseas types of partners, where we can see that kind of come up. You got to also think in this context about not just TCPA, because the issue of vicarious liability can span across a lot of different issues, including direct mail marketing, human resource vendors in the employment context. So a lot of companies will outsource some degree of their human resources, and maybe that is not always, they're not always on top of it. I've seen instances where human resource vendors have advanced a certain type of wage payment model that violated the Fair Labor Standards Act. That's going to go back on the company. You got to think about employee conduct. So even if an employee goes rogue and does something that's outside of the company's rules or policies, if they're acting in the scope and course of their employment, the employer can be held liable for what they do. And that includes not only things like discrimination and harassment, it also can include, for instance, if they're driving, harming somebody in an accident. We see it in the context of independent contractors providing consumer data, such as that kind of goes back a little bit to telemarketing, but it can be other kinds of data collected that may or may not have been properly collected in accordance with the law. And then, of course, going back a little bit to the data and privacy security piece, vendors providing IT services and support. You're going to want to make sure that those folks are buttoned up on how they're maintaining the privacy of your data. So that can come into play, like I said, across a lot of different issues for our clients, but we do see it, and it is important that if you are partnering with independent contractors, third-party vendors, that you are vetting those companies and making sure that they are reputable. It's good to get a recommendation referral from another company that may have used them for this type of service. And to also go back and make sure you are buttoned up on your contracts. We talked about contracts a little bit earlier, but make sure you're buttoned up on your contracts with these folks. I have had instances where clients have come to me and they have partnered with a third party for years and done a handshake deal and didn't have a contract. And then when things went bad, they went really, really bad. So even though you say a contract's not worth the paper it's written on, it is at least a way to set forth expectations and help if you ever face a situation where somebody is threatening that your business is liable for the conduct of another company. So that is what I have on vicarious liability. I hope that I answered our attendees' questions about outsourcing, but if you still have follow-up questions, feel free to throw those up in the chat. But with all of that, we talked about a lot.
Yeah.
So we threw a lot of information at you here in less than an hour. So the question I think probably that is in your head is, how do I manage all this? Because there's a lot of stuff. And so I think it goes back to what Erica had mentioned earlier. You've got to surround yourself with skilled people who either know the answers, can identify the answers, who can handle it, and or get you in touch with someone who is reputable to handle it for you.
Mhm.
And so with all these risks that our clients face and that we know companies face because we see it day to day and we consult day to day with clients about it, our firm is really bringing several different attorneys with a broad variety of skill sets, whether that's compliance, regulatory, litigation, and we have a variety. I think that our partners alone have well over 100 years collective experience. And so what we have started to do for some of our clients who have found it valuable is to offer a service called General Counsel as a Service, where we will, on a monthly flat fee basis, be available to you at a different tier of your choosing for whatever your needs are, so that you can call on us for compliance questions, regulatory questions, risk management. If it is something like a taxation issue, we might be able to handle it, but if not, we will have a network of people to get it handled for you. And I think that the biggest thing that at least the clients I've worked with on this have found valuable is it's a cost control. It's a line item. It's a flat fee. They're not going to get a surprise legal bill, and they're always going to know that they're going to have an attorney to be able to call when a need arises, and need arise often.
And I think, we deal with a lot of smaller companies as well as large companies, but, for a company that's, for instance, just starting up and doesn't have the resources to hire an in-house general counsel, it's great to not have the overhead and all of that. So,
and it's often even more important, I think, for a business in a growth mode, because a lot of times we see companies who are successful and they're growing, and that's fantastic. And we'd love to see that, but their focus is on growth. And sometimes they grow quicker than they are equipped to handle some of the, the regulatory landscape that's needed.
Yeah.
So with that, I don't see any other questions. Our information is on the screen. And if you have any questions and follow up to anything that we spoke about today, feel free to reach out. Or if you have questions about our general counsel as a service, feel free to reach out to either of us at any time. We thank you so much for joining us today.
Thank you.